All right. Well, first of all, I want to thank each and every one of you for being here. It's particularly good to see some old friends, people I practice law with, high school friends here. So thank you all particularly for coming. I'm going to talk with you about some of the transitional events that take place sooner or later in every single family. These are events that can make a real difference in people's pocketbooks. And I want to point out a few things that you ought to think about when one of these events takes place. Now, I know some of you are probably asking yourself right now, what are transitional events? Well, some of them are the death of a family member, a will dispute, the division of estate assets after someone's death, marriage, birth of a child, divorce, business startups, disputes with a business partner, decisions about newfound wealth, and estate planning. I've been doing this a long time, and I can tell you, if it weren't for greed and crazy, I'd be out of business. Greed and crazy. It doesn't matter how much money's involved. I've represented family members from just about every wealthy family in Atlanta, from Carlos to Candler, Woodruff to Rollins. The issues are almost always the same. And don't ever underestimate human nature's ability to screw up the best intentioned planning. If you don't have a plan to preserve your assets in these transitional periods, just know that somebody else will be planning what to do with your assets. So let's look at some of the things that can go wrong. First, let's talk about the death of a family member. Does everyone here have a will? Anybody here not have a will? It's okay. It's okay. Not very long ago, just a few months ago, a Fox 5 reporter came to interview me about a TV segment about wills. And despite having a husband, a child, a house, and some retirement accounts, she admitted she didn't have a will. And that was the focus of her story. If you don't have any assets, it doesn't make much difference. But if you do have assets, then it's going to be more expensive for your heirs, and there can be all kinds of problems. Under Georgia's intestacy law, and intestacy means that someone died without a will. Under the intestacy law, a wife gets a minimum of 1/3, and the children divide the remainder. Well, what happens? What happens when there's a dispute between the children of a first marriage and a second wife? And that's something that's pretty common. If there's no will, then there's no named executor. And so the court is going to have to appoint someone to administer the estate. And so if they're assets, both sides are going to want to control those assets. And so both sides file petitions to have their representative appointed as the administrator of the estate. And after waiting several months, or perhaps longer, the court schedules a hearing to decide who will be the administrator of the estate. And then you wait a few more months for your hearing date to come along. And then after a day or two of testimony at the hearing, the court is likely to say, well, I don't like either side's position. I'm going to appoint somebody else. I'm going to appoint a third party, an attorney, to handle the estate administration. It's expensive. It's time consuming. No one's happy. And now the estate is going to take a lot longer to administer. And you can bet, for the benefit of the attorneys, there'll be fees, and more fees. Be sure everyone in your family has a will if you have assets. Pick an executor that you know can do the job. Look at your will at least every 5 years. A will ought to have a maximum 5-year horizon. Look at it every 5 years and be sure it's consistent with your wishes. Be sure your executor can do the job. And not only a will, but everyone ought to have an advance directive for health care, which allows you to decide how your health care and end-of-life decisions will be handled. That should be a part of every estate plan. Will contests. What if your uncle's will doesn't say what he told you it was going to say? He told you you were going to get $3 million. And instead, your cousin gets everything and you aren't even mentioned. Is there anything you can do? There are several bases under Georgia law to contest a will. First is lack of competency. You don't see that very much because the standard for competency is pretty low. So most wills aren't challenged because of lack of competence. Improper execution of the will. Under Georgia law, you have to jump through several hoops to properly execute a will, but most of the time that's done correctly. Every now and then you'll get a case where you can challenge a will because it was not properly executed, but that's unusual. Undue influence. Undue influence is by far the most common way to attack a will. And there are 3 kinds of cases that we see regularly. Number 1, the children of the first marriage challenging a will that leaves most of the assets to the second wife. These cases are so common that the lawyers who handle them have a name for that second wife. It's Trixie. How do you deal with that situation? If the children of the first marriage and the second wife don't get along, or maybe there's just a lot of money, because if there's a lot of money, there's probably going to be a fight. Plan for it. I often have someone in this situation come in to see me and say, I don't want either side to contest my will. What do? I have the individual examined by a psychiatrist at my office to determine competency on the day the will is executed. I then have a videographer videotape the entire will execution. I have the testator, the person who's executing the will, explain why he or she prepared the will in the way that they have, and then execute the will on the videotape. Not so long ago, I represented a member of one of Atlanta's wealthiest families. His children had tried to have him declared incompetent so they could gain control of the assets. We won that competency case, and he then decided he wanted to cut them out of his will. We went through the steps I've just described. And when he died, about 2 years later, the children's lawyer contacted me saying that the children were going to contest his will. They were going to challenge the will. I sent the lawyer a copy of the videotape, and that was the last I heard about a will contest. Number 2, the second case we often see is a will of someone who has no children, and everything is left to one of that person's siblings' children, and another sibling's children are left out entirely. I handled one of these cases where on the first day of trial, the nephew, who was a beneficiary, admitted on the witness stand that he had gone to an attorney, had the will prepared, and then took it to his aunt at her home and got her to sign it. He and his brother were the sole beneficiaries. My clients, the children of another sibling, were cut out. And of course the nephew said, well, it was all at his aunt's direction. His lawyer knew that wasn't going to fly. We settled the case on the second day of trial. Often when one sibling's children are left out and another sibling's children receive everything, you're going to find a claim of undue influence. Number 3, lifetime transfers that are not discovered until after someone's death. And this can be a real problem. Not so long ago, I represented 2 sons of a first marriage in a case against Trixie, that second wife. The parents of the 2 sons had been married almost 50 years. The mom died. After a couple of years, the father told his 2 sons he had met someone at his church and planned to marry her. The father had about $6 million in assets, most of it liquid. The father and sons were very close. They discussed and planned for the new marriage. The father and the new wife executed a prenuptial agreement, and the father executed a new will, all designed to ensure that the sons would receive his assets. Nothing could go wrong, could it? Several years went by. The father's mind began slipping. The new wife took care of him. The sons were extraordinarily pleased by the care she provided the father. They complimented her. They were all close. But his mind continued to slip, and finally he died. The sons were expecting about $3 million each. They knew they were going to have to pay some taxes, but it was going to be, they were going to get a good sum. And they were right surprised when they got a letter from the wife's attorney. There was nothing in the estate except for an old Chevrolet pickup truck. The lawyer said he expected that Chevrolet pickup truck to sell for about $6,000, and they were going to get about $3,000 each. What happened? Well, the new wife had taken the father to the bank. She had him sign documents transferring all of his assets to her. There was nothing to prevent him from transferring those assets to her. And the folks at the bank didn't know that he didn't know what he was doing. So she had taken everything. Now, we were able to settle that case because her lawyer understood that no one was going to believe the father in this situation had intended to cut out his 2 sons. But if she had taken 60 or 70% of the assets, it would have been a much more difficult case. And it highlights the problem that unless the assets are protected, they can be given away by someone who's not on top of their game. There are all sorts of ways to protect the assets in this situation. For example, through the use of a trust. But whatever the situation, somebody needs to monitor what's going on with an elderly relative. Marriage. You're about to get married. The good thing is the divorce rate is declining. But still, almost half of all marriages end in divorce. Divorce among those over 50 is far, far more common than it used to be. Divorce among those over 50 is far, far more common than it once was. What should you do if marriage is in the cards? I encourage you to get a prenuptial agreement. Work out your deal while there's still a warm glow about the relationship. If the marriage goes south, you're going to save thousands, if not tens of thousands of dollars. Protect the assets that are yours, that you bring into the marriage. Money is not necessarily the issue. It's certainty. It's resolving a potential dispute before the dispute arises. I did a prenuptial agreement several months ago. If the parties get divorced, the wife was going to receive $500,000 tax-free for each year the parties were married up to 10 years. Now that's a pretty sweet deal for the wife. But the husband had what he wanted, and it was certainty. And he was not willing to put any more than that at risk. He had substantial assets. That's what he was willing to do. The wife was willing to accept it. They both know where they stand. There's not going to be a big fight if the marriage goes south. And what about divorce? The number one rule in any divorce is don't talk to your spouse about anything having to do with the divorce case. Don't talk about your conduct, your spouse's conduct, what you want, what you're concerned about, or what you discuss with your lawyer. Cases aren't settled because of what people know. They're settled because of what they don't know. It's uncertainty that brings them to the bargaining table. Rule number 2 for divorce cases: don't get in an argument with your spouse. Don't yell, don't cuss, don't threaten. It's too easy these days for your spouse to set you up and then record what you say. And that recording is probably going to be admissible, and it can really color the court's view of you. One bad sentence can make you look horrible to the court, and the court has concerns about you from that point forward. Walk away from any potential argument. Rule number 3, don't try to put financial pressure on a spouse by canceling insurance, closing credit cards, or cleaning out bank accounts. Don't cut off funds that you have historically provided a spouse to pay expenses. Courts hate it when one spouse tries to take financial advantage of the other. The court wants the parties to maintain the status quo during the pendency of the case. What are the common mistakes I see people make in divorce cases? For men, talking to your wife before you talk to an attorney. Failing to tell your lawyer everything. Telling your spouse there is someone else. Moving out of the home, particularly if there are children involved. Thinking you will get a better deal on the eve of trial. For women, the mistakes I see women make: waiting to file for divorce when you know the marriage is broken. Wanting to keep a home when it is not a good economic decision. Overvaluing personal property such as jewelry and furniture and furnishings. Trusting your husband after a divorce case has been filed. In my book about Georgia divorce, I have a story about a husband that I represented in a divorce case. The parties had significant assets. The husband also had a girlfriend. The husband had transferred assets to the girlfriend, even given her a credit card to use, and she'd run up a lot of expenses on that credit card. The wife continued to trust her husband even after we filed for divorce. She never hired an attorney, never did any discovery, didn't know what the assets were, and agreed to settle the case after a short discussion with her husband. She should have received about 3 times what she got. She thought she was being smart in saving attorney's fees. Instead, she got taken, and to this day, she doesn't know it. Human nature doesn't change. In divorce cases, in any situation, men generally want to believe they are in control. When you believe you are in control, you're confident. When the marriage has deteriorated and it's the wife who files for divorce, men are often surprised and on the defensive, much more so than a wife whose husband has filed for divorce. What happens when the wife files for divorce is the husband can lose confidence in both his position and himself. And the resolution of a divorce case is often based on who feels better about their position. And if you're lacking confidence, it can very much impact the settlement negotiations. A couple of years ago, I met with a lady who suspected her husband was having an affair. But she was not ready to file her divorce complaint. About 3 weeks later, she called me up and she said her husband had been diagnosed with prostate cancer. And she said he had told her he was flying to San Francisco to seek the advice of a specialist. He told her this was something that he wanted to do himself. She thought if he has a girlfriend, she figured the girlfriend was going, and she didn't know what to do. She wanted to go out there and be sure, but she was scared to do it. And she called me up and she asked me, what should I do? And I told her, get on the airplane, fly out there, go to his hotel room. If he's there with somebody else, you're going to know what to do. If not, you just tell him you couldn't stand the thought of him going through this by himself. It's a win-win situation. So she got on an airplane that afternoon, flew out there, went to his hotel, knocked on the door, and he wouldn't answer. And she kept knocking, and finally he came to the door, didn't open it, but told her through the door he was with somebody else. She got back on the plane, came back home, and we filed a divorce complaint the next day. And he was on the defensive from that point forward. It changed the whole character of the case. So when the marriage is coming apart, it pays to be decisive. Husband or wife, it pays to be decisive. The issues in every divorce case are the same. Equitable division and support. And where there are substantial assets, equitable division can be a huge, huge issue. With equitable division in Georgia, there are typically two concerns. First, the valuation of assets which are not liquid. A home, a closely held business, real estate, proper valuation is critical. And you have to work with your lawyer to be sure that they're valued correctly. If you don't, there's a million ways to be taken advantage of if you don't have the right valuation. To be sure that all non-marital property, separate property, non-marital property that you got outside of the marriage, such as a gift or bequest from parents or family, is properly identified as non-marital property, because non-marital property is not subject to equitable division. Oftentimes, retirement accounts were begun prior to a marriage and therefore are part marital and part non-marital. So you need to be sure those marital and non-marital components are properly valued. And when there are substantial assets, it's critical. It is critical that you have a plan for dealing with those assets from the outset. You need to plan with your lawyer what's going to be your strategy to deal with the assets. Don't wait until you're well into the case to develop that plan. You may have already said or done something that is inconsistent with what you now want to do. Develop the plan at the beginning. Finally, whether involved in a divorce or not, if you have separate property or non-marital property, either real estate or liquid assets, keep those in your name alone. There's a new Supreme Court decision, several years old, that says if you take separate assets, non-marital assets, that are in your name and put those in the name of you and your spouse, they become marital assets. Just changing the name, you've converted what was all yours to a marital asset subject to equitable division. Disputes with business partners. We often see partners in a closely held company or an LLC get into a squabble. What happens next is that one or two shareholders who have a majority interest decide they're going to squeeze out the partner with whom they don't agree. They withhold salary or benefits. They begin taking more money for themselves. There are all kinds of ways to cheat a minority shareholder. Hodge O'Neill, former dean at Mercer Law School and later Duke Law School, he's now deceased, wrote a terrific treatise about the oppression of minority shareholders and the multitude of ways a minority shareholder could be cheated. And several years ago, I had a large case, very large case, involving an effort by a majority shareholder to squeeze out a minority shareholder. And there was enough money involved that I could afford to hire Hodge O'Neill. In fact, the lawyer I was working with, Alex McLennan, and I went out to St. Louis to see Hodge. And I asked him, I went through my case, and I told him I wanted him to be my expert, and he thought about it a minute, and he said, well, Harmon, I understand the case, and I understand what you want me to do, but I'll just tell you, I don't think this is a case that I want to put my credibility on the line for your case, and I'm just not your man. And Mr. McLennan said, well, Professor O'Neill, I'm writing out a check for $25,000 for you. What do you say to that? And Hodge said, I'm your man. But anyway, Hodge was our expert in the case, and on his deposition, Hodge was asked by the opposing counsel how our client had been cheated. And Hodge said, young man, have you read my book? And the lawyer said he'd looked at it. And Hodge went on and he said, well, son, I believe your clients have used every technique mentioned in my book to cheat Caldwell's client. Shareholders don't have fiduciary obligations, but officers, directors, or managing partners do. A fiduciary obligation is the duty of utmost good faith and loyalty. It's the highest duty recognized in the law. So when that majority shareholder, wearing his officer hat, makes a decision that's not fair to the minority shareholder, that majority shareholder has breached his fiduciary duty to the minority shareholder. And the minority shareholder then has a basis to file a lawsuit And that lawsuit's going to include damages and attorney's fees and punitive damages. There's an old line that says, failing to plan is planning to fail. It's a cliche, but it's absolutely true in these transitional events. Poor planning is going to cost you, literally. The bottom line on all of this is when one of these transitional events is on the horizon, plan for it, talk with a good lawyer, understand what you can and can't do. Make sure you work with a firm that's experienced and has seen firsthand what can happen in each of these situations. Experience, preparation, and guidance will pay off. So that's what I've got to say. Thank you for paying attention, and I can hang around a few minutes if anybody has any questions. Thank you again.
Harmon, when would you use a private investigator instead of sending the wife out to San Francisco?
Well, she had to know for herself in that situation. That was important. And it just, one, we didn't have much time. He had already gone out there. You would recognize the name of who this was. But with her going out there and her knocking on the door and him not answering. In fact, what he did after that is, after about 10 minutes, she got on the elevator, went downstairs. He got out and ran down the steps and caught her in the lobby trying to offer whatever explanation he could. And it was just a disaster for him.
She obviously didn't feel physically threatened by him.
She did not.
Yeah.
She did not. But you know, it worked out for our case in terms of putting him on the defensive, and we ultimately got a wonderful resolution for her. And he was on the defensive from that point on. Yes.
When you're doing prenuptial agreements, and I'm thinking about the story you told about the wife who kind of took the $6 million out of the son's hands. Can you protect against that through writing terms into a prenuptial agreement that dictate how funds will be expended during the marriage, or is that only a...
Typically what a prenuptial agreement will do is say that assets that you brought into the marriage you get to keep, and assets that she brought into the marriage she gets to keep. There's usually not a prohibition against transferring assets. If you want to transfer assets to her, usually the prenuptial agreement allows for that. And that's sort of typical because you don't want to foreclose the possibility that a husband or wife wants to give or leave a bequest to a spouse. So that's left open. And the better way to have addressed that was with some form of trust that would allow or prevent his just being able to turn over those assets to her. Nobody thought of that at the time because the husband was in good health and good mental health when it happened. And that's why you've got to stay on top of it. If you get somebody who's getting old and starting to slip, well, what is the downside? What could go wrong? That's the question you go see the lawyer for, is how do I deal with a situation if things go wrong? You had a question?
Yeah, and maybe you just answered it with that scenario, but when you look at common law situations, and I'll just build a picture for you of where I'm coming from with this. There was this older gentleman that he had kids from a previous marriage, but then common law for many years with another female, and apparently I guess he would sign checks for her to go pay bills or whatever. So he died in December, and she presented a check on the date of death to the bank that was dated back for September to herself and wiped out an account that she was not a TOD on or POD on or any of that. And so what is a defense strategy in the common law situation?
Well, right now, there is no common law marriage in Georgia.
Okay.
Common law marriages ended in 1996. Now, if you have got a common law marriage that came into effect prior to 1996, then that common law marriage is still in existence. But she would have the burden of proving the common law marriage, of proving that the two of them held themselves out as husband and wife prior to 1996, that they filed, for example, income tax returns as husband and wife. But it's determined based on the facts of the particular situation. But if she's saying that the common law marriage came into being after 1996, forget it, no go. Didn't happen, because there's a law prohibiting common law marriage after 1996. Have I answered your question?
Yeah.
Okay.
I had a follow-up question to the prenup.
Sure.
So property is considered, I guess, either non-marital or marital. Can you talk about 401ks and how those are typically handled in?
Well, a 401k, like any other retirement account, where you see the biggest issue in divorce cases with retirement accounts is that oftentimes a 401k or retirement account was created before a marriage, or you work for an employer and that retirement account came into existence and you were putting in money into it maybe for 3, 4, 5 years. And then you get married and you continue putting money into that retirement account. Well, the portion that was in there before the marriage, plus the interest or earnings on that 401k, on that portion of the form, are separate property. Separate and non-marital property are the same thing.
Okay.
It's the same thing, and maybe I didn't make that clear. But that should go back to you as separate or marital property. It's not subject to equitable division.
Okay.
Whereas the portion that was put in after the marriage is marital property.
That makes sense.
So you've got to get a good accountant to figure out what was marital, what's non-marital. We're representing right now a fella who worked for Norfolk Southern Railway for about 35 years. His account, he worked there about 35 years. He had a retirement account almost 15 years there before he got married. And so we've had to go back and get the records from pretty far back to track through what did he have during that 14 years, and then run a calculation on how that has grown. And it's a pretty big number. And that was something he didn't even think about when he originally came in. Other questions or answers or suggestions? All right, well, thank all of you so much.
That was great.
Thank you.
Well, I appreciate it.